Hello?
Good morning. Who did I just admit on the cell phone?
Me, Rochelle.
I'm sorry, can you say again?
Rochelle?
This is
It's me,
Alicia.
Rochelle, Bob. Oh, I'm sorry, Alicia. It's Bob Fernandez.
Hi there, sir. I just wanted to know who I was admitting in on the cell phone. So thank you. Good morning.
Yep. Good morning.
Morning.
Hey, Greg.
Hey, how are you doing?
Good. Good. Audio's working, video's working. Hi, Aaron.
Good morning, Tom. How you doing?
Good. How you feeling?
Feeling a lot better than I was Monday. I'll tell you that much.
Yeah.
Still
What was it,
very
ear?
nasally.
Ear or sinus?
Oh, sinus, all sinus. Yeah.
That's it.
Not fun.
No, I know. That's no fun at all.
No,
Damn. Man.
usually.
Hi,
Tough
people.
time.
Hey,
Hey,
Brenda.
Brenda.
Hi, Brenda.
Tough time of year, too, to get a sinus infection. Because you're in and
It
out
was
of the
like,
cold. You know, you're in air conditioning. It's hot and
yeah.
air and hot. Make it
Well, it's
miserable.
yeah. We also have, we have the baby, and we have to keep the So there's a whole level of cold and hot and cold, and
Right.
that's just the way it is. I mean, it didn't hit me for 2 weeks, so I'm not too unlucky about it, because it could have been a lot worse. So
All right. Well, hang in there, man.
yeah, I'm here. Let's do
Okay,
this.
just a point of clarity, guys. Which agenda am I using? Because I seem to have two agendas for today.
They're actually the same agenda. There was just the start time was updated for the website. So
Thank you. Okay,
And then if you can all bear with me just one moment, Mr. Murphy's having difficulty connecting. I'm just trying to help him with that, and then he'll be joining as well.
okay.
Okay, I should just be a moment.
All right, that'd be great.
I don't suppose anyone on this call can hear what I can hear from outside. Probably not.
Pretty quiet.
That's
Pretty quiet
good.
from me.
Well,
Yeah.
there's a little known defense contractor called Ensign Bigford, not too far from me, and literally throughout the day, sometimes you can hear explosions because they're testing their products.
Okay,
Literally.
testing the products. I love
I
it.
mean, at least that's what I think they're doing.
And who is Bob joining us by phone? Is that Bob on the phone?
Yes.
That is me.
Good morning, Bob.
Good morning.
Well, while we wait for Jim, I want to thank you all for the postponement and pushing this meeting. That was me. I had a schedule conflict and I couldn't change the 9 o'clock, so I had to try to push it. Thank you, Alicia, for pulling that all together for me.
My pleasure.
And-
Anytime.
And thanks to everybody who rearranged their schedule for this. I appreciate it.
Happy to accommodate you, Tom. Actually, I always thought it was at 11:30. I don't know why.
Yeah, the 9 a.m. can be a little challenging, especially with the amount of documentation we have. I mean, just to pull together the documents for this meeting takes a half an hour.
We have
Did we get you, Mr. Murphy?
Yes. Hi.
Excellent. Okay, terrific.
Morning, Jim.
Good morning. Good morning. I was scrambling a little here. I realized I didn't have any contact number. So
All right. Well, then we can call the meeting to order. Lauren's here. We'll call the meeting to order 10:30. I'm sorry, 11:35, not on Central Time. And we have Lauren, we've got Bob, we've got Jim, we've got Brenda, and we've got myself as board members, and Alicia, Greg, and Aaron are on for the staff. So that's enough for a quorum. We're missing Sal. Is he our only absentee?
And Chair Palachi as well.
Ah, yes, that's right. Rochelle said she had a conflict. Okay, very good. Well, then I would proceed. Now, the first thing would be to approve the minutes of the June 4th meeting. And as I was going through the June 4th meeting, I recognized that we hadn't approved the April 22nd meeting. That's when I wrote you a quick email, Alicia. Is that something we can do, or do we need to distribute that and let it go? I mean, I looked at the April 22nd minutes. I'm comfortable with them. Quite frankly, if we wait another month, I won't remember what I did in April. So
Was it on the agenda?
it is not on the agenda. It's just for June 4th.
I mean,
So
you
part
can
of the June.
vote to add it to the agenda.
Okay. Well, I would vote to add the April
Actually,
20.
It's just a special meeting, right?
Yep.
Technically.
What's that?
No, I'm just trying to make sure we get the FOIA rules right correctly.
Okay, so I guess I'll entertain a motion to amend the agenda to add the April 22nd, 2025 minutes to our agenda for approval.
Well,
So moved.
Is that not good, Greg? Am I out
yeah,
of step?
well, because it's a special meeting, you can only discuss.
So, point of information. I
Okay.
thought we were a work group and not an official committee, so we didn't necessarily need to work within FOI guidelines.
That's not true.
That was the purpose of being a work group instead of a committee.
That doesn't make the distinction between calling it a work group versus a committee doesn't necessarily exempt you from FOIA
right.
laws.
Sure. Rescind my second. Special meetings agendas cannot be modified.
All right. Well, then we will not hear anything about the April 22nd minutes. Let's try to get those on the next meeting. The draft that you gave me, I'm very good with, Alicia, so you can distribute those for the next meeting. So
Okay,
let's
thank
talk
you.
about the minutes of our June 4th meeting then. The June 4th meeting minutes. Is there any discussion on those minutes?
Yes, I have a couple of edits.
Okay. Lauren, what do you have?
So the first one would be, let me make sure that I'm on the right page here. It's page, is it page 2? Am I looking at the April one? No. All right. There's language where it says, I wanted it to be just one section just be for 4E16 and 4E26. That needs to be corrected to 4E36.
Is that down at the bottom? Page
Um,
2 under new business?
Yeah, so it's under number 4, new business, the third bullet point. Change 4E26 to 4E36. It's just a typo there.
Okay.
And then throughout this whole Article 1 discussion, there's a repeated phrase that I feel like does not characterize the situation or the conversation correctly, which is Mr. Luciano and Ms. Gauthier want to take authority away from the executive director. That's not a correct characterization. This document cannot and does not um, provide authorities to the executive director. I think a more appropriate characterization of what we were trying to do was clarify authorities, right? This document can't give authority, I guess. It can delegate maybe, but it reads as if we're trying to do something that countermands the statute, right? I'm really pushing back against this wording that's used throughout. No one's trying to take authority away from anyone. It's more like we are not providing or imbuing an authority, which is very different than trying to take away an authority that doesn't exist anyways, right?
Okay. Yeah. So would it be remove? Remove the executive director in this section?
Well, just delete language that, right? Because as we discussed, pretty much throughout this, it's discussing that the chair is the one who is making these appointments, right? We're reserving the authority to the chair as opposed to delegating the authority. That's the modification that's being made throughout. So if you want to say something like Mr. Luciano and Ms. Gauthier want to reserve the authority to appoint to the chair, and that would make more sense because that authority rests by statute with the chair, or does not want to delegate that authority to the executive director. Can say it the same way but differently. But no one's taking any authority away from anybody. First of all, the authority doesn't exist. One, it's more a matter of not imbuing the authority in the first place.
Okay.
I
Well,
feel like that's a significant distinction and a significant characterization that needs to be corrected.
okay. All right. So as far as taking authority away, we can't use that language. How many times do we use that in here? Let's see, 1, 2.
1, 2, 3, 4. At least 4.
Which ones are they? They're 147. I see 4E16. Where else?
Yep, sorry, I scrolled down to the bottom, so it's 4E27 under Article 2, 4E26 under Article 2. Scrolling up, and I'm just, it's going to be throughout. 140 tax 16, consolidation of proceedings.
Mhm. Yeah, I've got on
Keep
47, 4E16, 4E26, and 27.
147. Yep. So that
4 times.
4. Oh wait, hold on, still going up. Yep. Okay. Yep. Those 4 times. Again, I just scanned it, but that all needs to be edited. And I'm going to reserve voting on it until I see edited minutes. That's just my vote personally.
Okay. And what language can we put in replacement of remove authority? Remove
Like I
the
said,
authority.
reserve authority to the chair, I think would be more appropriate. Characterization of what was discussed.
Reserve authority to the chair. All right.
To delegate,
Well,
yeah.
okay. Well, I see what you mean about the authority point, because I was there and, I thought you both did voice you wanted the executive director removed from that clause. So I don't know that removal is a bad word for that. I mean, that seemed to be the intent. Am I wrong?
Right. No, I mean, the way that it was originally written was that the executive director, without direction from the chair or from the board, would be appointing whomever to take these actions, or retain the actions by himself. And the point of the discussion was that the board or the chair should be making the direction on how these proceedings unfold and who is leading up the effort, right?
Yep.
That's the competence of the chair or the board to decide who leads the effort on these hearings.
Okay. All right. Well, I would edit these minutes to take out authority and just want to remove the executive director or designee throughout, and that would be want to remove the executive director, want to remove the executive director. Yeah, we will take out any reference to authority because this document has none or doesn't designate any, as you mentioned. So I would say that I would like to approve the minutes as amended. 4E36 noted, and take out the language in 4E7, 4E16, 4E26, and 27 to remove the word authority from the, and just state wants to remove the executive director. That's about as straightforward as I can say it. What's that?
Okay. No,
All right.
I'm agreeing with you. Yes, thank you, Tom.
Okay. Well, then let's do that. So any other discussion on the minutes? Hearing none, we'll take a vote. All in favor of, well, I need a motion, right? Somebody move to approve the minutes as amended.
This is Jim. I'll move that we approve the minutes as amended.
Okay, thank you, Jim. And a second?
Second.
Okay, thank you, Bob. So moved and seconded. All in favor of approving the Wednesday, June 4th minutes as amended? Aye.
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 Opposed? Abstentions?
Me, I abstain.
Okay, thank you, Brenda. Yeah, so that takes care of the minutes. Very good. Roll call minutes. So let's get into our old business. I went through the documents as amended. And yeah, I mean, they're looking really good. I went through part 1. I just had, one question. Maybe some of you also have a couple of questions. I think the best way to approach this is maybe just go part by part and see what people's comments are. So I will start. at 4E6, because I believe that's the first amendment to our part 1. So 4E6 is the clerk of the board acting clerks. There's some editing there. I found this language that has been edited. I find this to be acceptable. Anybody have a comment on 4E6?
Are we looking at the main document that was sent? I want to know what I should be looking at.
Yes.
Or should,
Yeah, the main document. Yep. That's our one and only. We've been working on this for a long time.
All
I
22
know.
pages.
Okay. I got it.
Yeah, so 4E6 just talks about the clerk
Mhm,
and, the clerk being able to, or may, sign and certify as true copies and disseminate,
mhm.
at the discretion of the board. So I find that to be okay. Then let's go to hearing nothing else. Let's go to 14E7, hearing officers. So the hearing officers, I think this was edited pretty much the way we had discussed at the last meeting. It looks good to me. I had a question on the last paragraph where it says, let's see, a regulation waiver may be warranted, right? The hearing officer must first inform the board or its chairperson for determination on the merits. And I'm not sure about the word determination. I mean, when we say determination, is that something that if you're a hearing officer and you want to give a waiver and you notify the board and the chairperson, does the chairperson have to formally make a determination? Or is that something that can be done through discussion? I mean, I'm just curious because when I saw determination, I thought, oh boy, well, now there's going to be another level of who makes the determination and how is it disseminated? And I don't know if there's a different
That's a
word we
valid
can use it.
That's a valid point. And I think it can be consolidated. You know, when I was thinking about how to edit that particular part, I believe that there was discussion about on one hand, giving the hearing officer a level of autonomy to proceed with these type of matters, but at the same time, keeping some sort of command and control, especially as it pertains to waivers or regulations, at least some level of it with the chairperson board. So I think maybe that word can just be, well, first of all, if you want the autonomy to solely stay with the hearing officer, obviously we could use something different than determination. The whole thing would be revised, that sentence. But if there wants to at least to be some, to inform them, and then that would be it, and then keep the determination with the hearing officer, then I can separate the two sentences and just make, for clarity purpose and sort of your separation of sort of duties and authorities here, for clarity purposes, revise it, maybe make it into two sentences and just make it clear that the hearing officer is making the determination, not necessarily the board or the chairperson, but that's what we're here for, to discuss and work out.
Yeah, I was wondering because I would think a hearing officer, if they have to make a waiver, it's likely to be calendar or whatever, and then they're probably going to have to make it on the fly. They're going to say, okay, somebody can't get this information back to us by X, so I'm going to allow it to come back at Y, and they sort of have to make that on the fly. To have to make a phone call or get permission to do that doesn't seem constructive. But I think a notification to the board chair makes sense. So
Yeah.
here, if you just said that we first inform, and maybe not first, but the hearing officer must inform the board and its chairperson of the merits of whatever the waiver is, so that, the hearing officer sees that it's a proper thing to do, does it, then notifies the board and tells the board, explains to the board, this is why. Here are the merits of why the waiver.
I mean, I wasn't there for your discussion, but that makes sense. As opposed to I wasn't sure what the determination meant, that the board had to approve or not approve, but if the goal is hearing officer should make that decision, but explain it to the board, then that makes sense.
Yeah, I mean, I think that would be the proper sequence because the hearing officer is going to be, really into the whole hearing and all. The board is up
Yeah,
here.
of course.
The board's going to, well, okay, if they hear of a waiver and then they have the explanation to the waiver, I think that's adequate. If
Correct.
anybody had a comment about that, then, we certainly have a discussion, but I think that's for now, for these regulations, that would be the way to go.
Yeah, that's fine. I will make that slight revision for the next draft. Not a problem.
Okay. All right, great. Thank you, Aaron. So I'm going to move on. Anybody else have anything on 4E7? Not hearing that. 4E11, that was satisfactory to me. Where good cause appears, the board or at the direction of the board, any hearing officer may permit deviation, blah, 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 blah. I think that's fine. And then we get on to my favorite. I'm sorry? Then I get on to my favorite, computation of time. This is one clause that this thing has been beaten and battered and
Yeah.
okay. So
I left the original, all right, just so people
Okay.
have some context. So by all means, destroy it again if you wish.
No, I think it's good. I just when you start with the first counting the next calendar day. So the very first sentence begins by the first counting the next calendar day. And I think we have to just say what that is. The next calendar day to what? To the receipt of the
Yeah.
information, to
Okay.
the filing date? Because later on in this article, later on it says it talks about filing date and that the board will receive it on the date it is filed. But I think
Yeah.
here for computation of time, we may want to say the date after the filing date. And then in 4E24, when we get into contested cases, it actually says the time frame is going to start on the date that it's filed. So is that in conflict with this? Do we have to make it more consistent?
Well, so just for some context on this, there was what I had originally used was precipitating event. And apparently that caused some confusion amongst some of the members. So I took it out. I think we should have such terminology in there. I think it's self-explanatory. The precipitating event literally is an all-encompassing language that accounts for something like a filing, and potentially other types of occurrences that then trigger these rules of practice. So I personally think that we should put it back in. And if we want to have a discussion at a later date about what that means, we can. But I think it's pretty self-explanatory that when one thing happens, other things can occur. So, and whatever that one thing is, if we want to work out the details and part of my language, but beat that dead horse anymore, we can. But that's what was in there before. I took it out because there was some confusion, I guess. But that's what was in there before. I think if we put it back in there, it would satisfy your concerns here.
Okay. All right,
Lauren.
Thanks, Aaron. I think we have to clarify. So, Lauren.
Yeah, I'm going to maintain my stance that this is overly complicated and could potentially conflict with our statute. Specifically 4E36, I'm thinking where that 30-day timeline, we've always operated it as calendar days being triggered from whenever the contested case was sent to the board. And so to Aaron's point about precipitating event, well, the question is the precipitating event anytime anybody reaches out to any member of the board or staff of the board, or is the precipitating event the day that you say, yes, I received it, it's filed, we put a number on it? Those are two very different things depending on when it's received, like a day or a holiday or whatever. But the fact of the matter is the statute has always operated, and I believe is very clear. 30 days is 30 days, regardless if it's a holiday or regardless of if it's a weekend. And we have always worked within those confines because that's the statute. A day is a day, 30 days. And my concern with how this is written with all of this, well, if it's a Sunday and you bend over twice backwards, it's confusing. And again, I think it's going to run us into issues if we do not complete within our statutory time frame, because we're trying to shift when it actually starts and when it actually ends depending on a holiday or a weekend. A day is a day. I don't know why we have to be any more complicated than that. It serves nobody. We have never been unable to meet our timelines, considering a calendar day is a day, and the fact that that's how the state operates. I don't see why we should try to do anything different. This is overly complicated.
Okay,
And
thanks, Lauren.
that's just
Yeah,
what
I mean, I don't really see it that way. I think this is a calendar day. I mean, it's all about calendar days. And, you know, if it falls on a Saturday or Sunday, it goes to the next date that the office is open. This is really identifying the first day and the last day, and everything else are calendar days. So I don't see this as being overly complicated. It's talking about 5 days or less. And so if there's some period of time that's 5 days or less, then we get to exclude holidays and weekends. But anything that's more than 5 days is a calendar day. That's pretty much what this is saying.
But
So,
why make it any more complicated than just saying 5 days?
well,
Why make it more complicated? I don't think it serves anybody, and it only adds confusion.
I'm finding this very confusing. And I know I wasn't part of all your discussions, so I apologize. Why wouldn't it just be calendar days? Like, why is it so detailed? I guess is my question.
okay.
I mean, I don't want you to rehash your a million conversations about this.
No, I
So,
know.
I'm reading it and I'm as
Could we
confused as
answer-
can
could we
be. I don't
answer-
understand what this says at all. If it's
Right.
calendar
Who does this
days,
serve?
why aren't we saying calendar days?
Maybe Aaron can answer that. Who does it serve, adding all of this additional hoops and whatever else and clarifications?
I would say that it serves it serves those parties that are potentially involved in a contested case, and it ensures consistency and clarity for those parties. So therefore, it really has to do with due process and fairness. And I know it sounds confusing, uh, uh, but I don't know what else to say other than that certain things need to be spelled out. And also to speak to your point, Lauren, we can do carve-outs here. If we wanted to put a carve-out to say, unless statute says otherwise, for instance, 4036. But I also would also want to put a mention about 4036 is that that's not a contested case. But we could still put a carve out for any statutory language that supersedes this regulatory framework. But back to what I was saying is that making sure that the parties that are involved are understanding what is and is not included in the computation of time, and for purposes of 5 days or less, how, and this is if you look at other regulations and other agencies, this is very standard on how they use it as well. So it's been vetted, and I'm comfortable with using what may seem like a little bit more overly complicated language, but it makes sense from a purely fairness and due process standpoint. So
Yeah, and this is half of what it used to be. Lauren?
yeah, yes, it is.
Yeah. My only thing is, when I'm thinking about operations by both agencies and the public, right? The folks who are going to be bringing us contested solicitations are going to be lay people, business people, the public, members of. They're not necessarily going to know all of our bylaws here. but they know what a day is, a calendar day. And so again, adding all of these additional things, I don't think serves anybody. We have always been able to operate within a calendar day. And I think it's so straightforward, it doesn't require any other clarification. And who it ends up being, and I don't think that it reduces anybody's due process either. A calendar day is a calendar day for everyone in the world, right? The 24 hours is a 24 hours. This adds complication, and I think it reduces folks' ability to really engage with our statutes appropriately. Because if they think they have 30 calendar days for a resolution, and then it turns out to be 45 because you hit that perfect sweet spot in the winter where there's all these holidays, and it's, I completely disagree with having anything other than a calendar is a calendar day, or a day is a calendar day. That's just where I am
All right.
ending all of my comments on this.
Okay, all right. Thank you. I think that we might be able to get it a little better. I'm not sure why we added the 5 days and 5 days or less. I'm not sure. Is that for hearing officers? But if they're in the middle of a hearing, they can easily say, I want this by next Thursday.
There's
So-
there's a lot of room for deviations in mostly there's a lot of room for deviations
Right.
in the middle of a hearing by the hearing officer in real time for the good of the order, so to speak, and for quote unquote justice, so to speak, these sort of higher level principles, and that's the way it's meant to be. It's meant to be flexible, right?
Yeah.
It to an extent, right? There's still some wide guardrails, but anyways, point being is that the whole 5 days thing, again, I borrowed that language. It's widely used. It's meant to to not have to, when you need something quick, to not have to be stuck and bound by this well, the weekends are excluded. But yes, I mean, there is flexibility. It's meant to be flexible. If we wanted to take out the language that spoke about 5 days and put again some sort of qualification or caveat that we can, but again, this was this was devised thinking about what other agencies do, what makes sense to me, and for purposes of fairness and due process. But you all let me know if you want me to revise this. I can make it a little bit simpler. It's up to you.
Okay, well, I'm going to suggest we take out the 5-day event. I don't think that needs to be in there. That does sort of overcomplicate it. And we can just say it's basically that the computation of any period of time referred to in these sections, inclusive the proposed regulations of the state agencies, begins by counting calendar days, period. And then if you want to say what the first calendar day is going to be counted as, is it the day after the filing date? That's the first day. And then on the last day, if it falls on a Sunday or holiday, it would be the next business day that the office is open. I think that sort of simplifies it. That's it. We count calendar days. We start the day after you file, and we end on 30 days later, unless it's a Sunday or a Saturday or a holiday. In that case, we will go to the following Tuesday.
Right.
Maybe just say that. All right.
Roger that.
Okay. Hopefully that's going to be the last bite at that apple.
Hopefully.
Okay. Thank you, Aaron. I mean, I know you've really worked hard on this, and it's like doing laundry. Got to separate the white. Got to separate the whites and the colors. It's like, ay. Okay, moving right along. What do we got? 4E14 extensions of time. Yeah, I didn't have any issue with 4E14. I thought that was edited properly. Any questions? Anybody?
Yeah, just a typo on that first line. Any hearing officer may extend. I believe you meant extend.
Yeah.
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 Alicia, question. I had emailed you my red lines and edits prior to last meeting, or what I thought was prior to, but I had it on my my calendar for an 11 o'clock. I think I sent it to you sometime around 9 in the morning. Were you able to distribute my red lines and edits? I realize now that I didn't get a follow-up from you on that. And I kind of sent it to the whole group.
Okay, I
So,
believe it went out to the whole group. It would take me a minute, because I'm taking minutes as we speak. It would take me a little bit to go back through my emails and follow that paper trail. Believe that that Attorney Feldman did receive that as well, though. I think everyone did.
okay,
If
yeah,
that's not true, I can certainly go back and forward it over, but I believe that they've been working off of that in preparation for this.
Okay.
Okay.
Yeah, I did
Just
not
wanted to
have a
make sure everyone
chance.
got it.
Yeah, I didn't have a chance to look at that. Lauren, I don't know that I received it directly from you, but I think Alicia sent it to me or Aaron sent it to me. Somebody sent it to me. But I did not have an opportunity to look at it before this meeting.
Okay, not a problem. I've got
So
both up.
what was the typo in 4E14? Any?
4E14, where good cause appears, the board or at the direction of the board may, any hearing officer may extend. It needs to be changed to extend,
yeah,
T to a
extend.
D at the end of there. It's just a typo, that's all.
Just the right,
Gotcha.
just the,
Okay.
yeah.
Okay, there you go. Yeah. See, that's why I'm an engineer. English is not my forte. I
I thought you were
like
gonna say
numbers.
English is your first language. That's
Yeah, well, unfortunately it is. Okay. So 4E15, effects of filing public records. I think that's all in order. 4E16, consolidation of proceedings, also appears to me to be in order.
Yeah, I think I had made the recommendation to strike out everything after or at chairperson. So strike out or at the direct, which should be direction of the chairperson, the hearing officer, or the executive director, or his or her designee.
So to consolidate proceedings, you want it just to be the board chairperson or nobody else?
Or his or her designee. Well, no, it'd be his or her designee, and whether that designee is another board member, the executive director, the hearing officer. It just, you're making a list and then extending it with his or her designee. You could just use fewer words, I guess. But if not, I have no problem leaving it as is. Just the word direct needs to be changed to direction if you leave it as is.
Okay, I can do that. It's not a problem.
Yeah, I mean, I'm not. I'm in favor of just
I'm just
leaving
in
it the
favor
way
of
it is.
fewer words
That's
in
fine.
general.
All right.
No, it's a
Yeah.
valid point of what Lauren's saying. I'll change it to direction.
Yep, okay.
Change to direction.
Okay. Very good, very good. Okay, so we're moving on to 4E18, ex parte communications. I read through this. This all seems to be in order to me. I didn't see any conflicts. Any comments? Good. So then we get into section 4E19, date and mode of filing. So this was, yeah, very interesting. In all papers, blah, 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 required by, filed with, transmitted to the board. We're following, the Superior Court standards. And we give them an email address. I think this is pretty good. Any comments? All right. Hearing none.
Well, I had one thing. I think I mentioned Tom earlier that regarding hand delivery, that if we want to have hand delivery, we would need to actually physically create a box and maintain that box. Just FYI, in the event, in any future event, hand delivery is very much accepted and always has been in the Superior Courts as an acceptable mode of filing, where you're handing it to the clerk physically, to the court clerk, and as well as other means and methods of basically completing certain requirements that might be required by the court or some of its sub-agencies. Anyway, so just we don't have to have it here, but it's a very, it's it's one of the foundational parts of an accepted means of filing. So since we don't currently have a box, it's just something that I think that this group needs to consider potentially in the future, if we needed to ever revise it, or if we get in a contested case situation, you know, just to kind of, you know, try to not have to deal with the headache of some party complaining about the fact that there's no hand delivery, you know.
Okay. Well, would you
Can we
like
take
to,
care of it? Can we take care of
mean-
it right now? Probably not, but just, you know, for future purposes, hopefully that's not for a long time, but just, you know, have to do my diligence here and let you know that we don't currently have the ability to do this, but, you know, keep it on the back of your mind, you know, whatever we ever have, hopefully never have to deal with it. But if we do, you know, it's something that we might have to sort of deal with eventually. But anyways, that's all I had to say.
did you want to add
Don't
a
mean to muddy the
sentence?
waters.
Yeah, I mean, if you had a sentence saying hand delivery is allowable at the principal offices of the State Contracting Standards Board, just put a final sentence in there, opening the door for hand delivery.
Yeah, but the problem is the you know, there's a security uh uh I guess post, you know, they'd have to, you know, I'm just thinking, you know, practically they have to get through that, and then we have a locked door, right? So, you know, we could keep, yeah, anyways, we could talk about this later, but the details need to be
darn,
worked
yeah.
out. Need to
Yeah,
be worked out before. What's up?
Just say hand delivery is allowed, good luck. I mean, you know, you
I'm
gotta get through
I mean,
security, you
other
gotta do
I
this.
offices,
I
I
would
mean,
like to avoid that type of
I think
situation.
then
Aaron,
don't bring it
the
up,
office,
man. We were this close to approving that clause.
I think you can approve it. I just think that we need to be aware of that moving forward.
Okay, Lauren, you had a
office
comment?
can,
Oh,
I'll
sorry,
let Bob
Bob?
go.
Yeah, please, Bob?
yeah, what I'm saying is that the Office of State Ethics solves that problem by having a locked box by the elevator there in their lobby
Yes,
with a
yes,
phone number there to call if you drop something in the box.
correct. I mean, that's
So
essentially what
think
you would
that-
need to do, but we'd have to get
Right,
that set up
right.
before we do anything.
Right.
So,
Okay, well then I would say let's remain silent on this and we'll add it later. Lauren,
yeah,
did you have a
it's,
comment?
My comment was exactly the same as Bob's. Great
Oh,
minds
okay.
think alike.
Okay,
yep.
there you go. All right, good. Well, then I would leave this as is for now, and yeah, let's just keep in the back of our mind, hand delivery. 4E21, identification of communications to the board. Case number has been changed, so I think that's good.
Yeah.
4E23, service, general rules of service, the same as the Superior Court. And then a large paragraph on service of briefs and memorandums and all that stuff at the discretion of the board, the hearing officer. Yeah, I read through this. I thought it was all good. The 4E23. Any comments? All right. Hearing none, we'll go to 4E24. And here's where in 4E24, the commencement of contested cases, it says a contested case shall be deemed to have commenced on the date it's filed or it's recorded, received and indexed. And so that's why it sort of conflicted with the other computation of time saying the next day. So do we want to keep this in here as far as the received goes for commencement of these contested cases, or do we want to say, you know, the next calendar day? Ben?
So if I'll just kind of chime in, you know, this is pretty standard as far as the commencement of a contested case, or you know, whether so it's sort of like a carve out, right? It's saying for the commencement of a case and of a commencement of a contested case only, the time is whatever whatever pertinent time constraints, requirements that exist at or immediately thereafter the commencement of that case will start when it's indexed. So when it's been assigned an index number. So this is very standard amongst the superior courts. You know, you can file something, but until it gets its case number, doesn't actually exist. At least the commencements of the case. So it's just a carve out. I wouldn't even say it conflicts. It's just a carve out for that specific type of situation, if that makes
Okay.
sense.
Yeah, no, that makes sense. All right, well, in that case, I think 4E24 is good. And
So,
looks pretty good.
Yep,
Lauren?
my comment there, I had a similar question, and the comment that I had sent in my red lines was that to resolve this, the date that the complaint is received, period, following receipt, the case will be indexed and provided a case number. Right, that's, I had this whole blurb, contested cases commence on the date the complaint is received. That's the statute, right? So I guess, is this attempting to define what receipt is? And then we go like, well, who's the right person to receive it? Because we don't want it to be any board member. I think it should be received by probably the chairperson, right? So the executive director or the chairperson, or the executive director gets it. And I think that you guys have a portal now for these, right? Or is that just, there's something on the website? That's a question.
I'm not
Mm-hmm.
immediately
Do
aware of
you
this
have
at the
a-
moment.
You don't know if you guys have like a portal set up for folks to send contested cases to or inquiries?
I think it's just an email. I don't think it's a portal. I mean, correct me if I'm wrong, Greg, but
It's just an email.
yeah, it's just an
Okay.
email.
So are we
And
counting it from the moment that someone sends it to that email? Is it like forwarded out to somebody else's email, or is it like a constantly monitored inbox?
We have a SCSB email address that people send all inquiries to. That
Okay.
we monitor.
So the reason I'm just being like a little bit touchy about this is from previous experience, I know that the courts have upheld that, and I don't have the exact like case law, but they essentially treat email as if it was like certified mail. So like the time that it's received in an inbox, that's when it's received. So if we're going to define received by the board as something separate than when someone just sends an email, I don't want to overcomplicate things. I just want to make sure that when we start, especially for those cases that we are time limited on.
So let me just chime in real quick, Lauren. What you bring up is important. So, but let me give you a little context. So, mode of filing is important here. So, in mode of filing says we can send it to this email. Party sends it to that email. It's sent, right? After that, then you have the commencement of the case, and at that point, there will be notices sent to the parties. In those notices, they will then find out exactly all this information and what the timeline will be accordingly. It'll reference that index number or case number, and then the matter will proceed accordingly. So by virtue of this process, of this procedural process, there shouldn't be any confusion. And again, this is all very standard. So, we have a certain number of days that we have to send out those notices. So we have timetables for that. So I think that because there's the standard process that although these confusions are you bringing up your concern about these confusions are valid, I think if we stick to the process, this standardized process, that it's worked, it has worked, it will work. That's really all I could say.
Yeah, I mean, I think we should just put the words by the board in there, so it's received by the board. I mean, if somebody sends something to our email at 10 o'clock at night, we're not going to see it until the next day.
Yeah.
And it's got to be received by the board. Sometimes Greg may get an email at 4:59 and he didn't see it. He sees it the next day, disseminates it to us. I think we should just generally say received by the board and leave it there.
What's index mean? Given a number? If
Yeah,
it's received
it's
and
gonna give it-
indexed, it doesn't have to
yeah.
necessarily be the same moment, though.
Right.
No.
So you get the email
Date of
and it,
receipt and filed are two different.
Yep.
so,
So the courts
you
treat it
could- you could
differently,
get-
receipt versus filing. Received and filed, so like for docketing purposes, receipt versus file are two different things for the court.
Yep.
so,
And oh, sorry, Brenda.
no, go ahead, Lauren.
Well, the distinction being important there is if we're counting our 30-day time frame on like a 4036 based on date of receipt, defining what receipt is, because it doesn't matter when we file it and give it a number. If we receive it and we sit on it for 5 days, well, now the board only has 25 days to act, right?
Yeah.
And God forbid we receive it on the 23rd of December, which I know we've done before. We can't, when do we start counting? When we index it, when we get back on January 2nd?
Yeah.
No, it's got to start on the 23rd.
So I'm gonna just say on that 4036 is not a contested case by statute. So when we're talking about contested cases here, we're just talking about contested cases. We're not talking about 4036. So
I'm sorry, the statute titled contested solicitations is not a contested case.
contested solicitation, meaning that someone is going out there, some party, some interested party is saying, I'm going to challenge. That's just a choice of words that doesn't necessarily, it doesn't have the legal meaning that a contested case has. Only by statute, identified by statute, is something a contested case, or perhaps out of a higher level due process, for instance.
Right.
The courts have said that even if the statute doesn't specifically say that UAP applies, you could still have a contested case for something like due process. But I've looked at 4036. I've done the research. 4036 is not a contested case. I'd be happy to discuss
So-
this in length with you, but it just is not.
Okay, I think that that's important to what we're doing here, because why would any of the other operations that we are allowed to make under statute be considered contested cases? Removal of contracting authority is considered a contested case.
So if you look in each of these,
Disqualification of bidders.
so it depends what you're talking about. If you go into the statute, you will see that at the end of certain parts of each section, you will see. Let me just pull up one. I'll give an example here. We'll go to 4E35, for instance, and 4036 and 37. So at the end of 4E37, right? J, it says a decision issued by the, so this is the appeals, right? It says that it's actually saying here that the decision issued by the board or appeals review subcommittee under the section shall be final and not subject to appeal under sections 4-180, 4-183. So that's saying that's basically saying that it can't be appealed, that a certain part of UAPA is not applicable, etc. Go to 4E, here we go. Go to 4E35, the suspension of contractor, bidder, or proposer. It's saying in that A, the last sentence, such decision shall be a final decision for purposes of sections 4-180, 4-183. So the final decision is the operative wording here, because only a contested case can come out of a final decision, which has specific legal meaning, and only a final decision can be a contested case. So since 436 does not list that the decision is a final decision for purposes of UAPA, it's not a contested case.
All right, guys, I think we're going way
Yeah,
far afield here.
we
Yeah.
could go
I'd
on
like
about
to,
it.
I would like to.
Yeah.
I do have
on
to get
this-
going. Could I
Okay,
make the request, Aaron, that you write up these distinctions that you're finding, and write up a memo for the whole board's consideration? And just kind of
Well,
distinguishing
I-
between which of these types of cases would be applicable under UAPA and which ones wouldn't be.
So.
Yeah, I
I'm-
think,
I'm
Lauren,
glad-
what I'd like to do is get to, 4E 35, 36, and 37. Right now, we got up to 27 last time, and we haven't even gotten through
Yeah.
all of the edits. So I
Lauren,
just,
let's talk
uncontested-
more offline about this, as far as like getting a potential memo and seeing, when that could be a viable option. I'm not saying that I'm not going to do it. I'm just saying, let's talk more offline about this, okay? If that's
Yeah,
my only
I think
request.
that makes sense so that you can, consolidate. So when the work group gets to 4E 35, 36, 37, you guys will have a consensus when we get there. It'll be a better
Yeah.
use of the work group's time.
Yeah,
All right.
yeah. I
So
don't
what
think
do
I don't think it's a bad use of time. I think it's very much a good use of time for purposes of the board, for purposes of everyone.
Agreed. But we need to get through
It's
the
but
little
it's not
things.
it's not necessarily a very simple task, because you have to go into every single part of each section and really it's just a very involved process. So it could take significant amount of time to draft. So I only say that to mean like I would just like to discuss it more as far as like timeline, getting it out to you when you would like it, et cetera, et cetera. So let's, if you don't mind, if we could just discuss it offline a little more. That's my only
Okay.
request.
All right. Agreed. Do that. 4E 24, the commencement of contested cases. Are we just going to add the words by the board? Is that acceptable to everybody? Having been received by the board? And anyway, that's my vote.
Well, I kind of think that received and indexed as a contested case by the board inherently means that it's being received by the board, since there's
Yeah, I
no,
mean, well, received, you want to say received and indexed by the board? Or just received by the board and indexed?
I would feel more comfortable just from my standpoint, received and indexed as a contested case by the board, which is what the language says initially.
That's exactly what it says now.
Yeah, exactly. I think
All right.
I personally think it's good as is, but you all tell me.
All right. Well, I'm in favor of what's there. No changes. Okay.
I'm in favor of what's there, Tim. I think it's clear.
Okay. Gotcha. All right. 4E 25, the form of the complaint. I read this. It all seems to be in order. I didn't see any issue with that. 4E 26. When we talk about the procedures in response to complaint, you say the chairperson hearing officer is designate. Should we say the board chairperson? Or are we talking about a committee chairperson or a work group chairperson? So I don't mean to throw, a fly in the ointment, but
Tom, it should be via so chairperson is defined in the definition section. So it says under B3, chairperson means the appointed chair of the board. So there you go.
okay, good. And that was all I had on 4E 26. So that works
Easy
out
peasy.
good. Yeah, that works out good. Sorry, I didn't go back and look at the definitions.
It's okay.
I'm trying to move
that's why I'm here.
forward. I'm trying to move forward in this document, not backward.
Well, I've had to move forward and backwards many times, so no worries.
Understood. I've read this 4 times
Yeah.
already.
I've read it dozens of times.
Okay.
It's no
So
problem.
the designation of parties, I was reading through that. It seems to be, as we discussed last time. Yeah, I mean, and no party having been designated as such shall be removed as a party. So, I mean, it's basically saying, once you're locked in, you're a party to the hearing, right? And you will not be removed. All right. Anyway, it all seemed legit to me, 4E 27. And then if we could just do 4E 28, the interveners, and go through 4E 29 and get to part 2, which is actually hearings, then maybe at our next meeting, we can start at part 2 and move forward. I think all the edits we just discussed in part 1 are all manageable, right, Aaron?
Yeah.
Okay.
It's really not as complicated. The only thing is obviously the continuing saga of the computation of time. But I'll get that squared away.
Okay. So Anybody have any comments on the interveners section for E28 or representation of parties and interveners for E29? I myself did not have any comments. I looked through it. It all seems to be in order to me. All right, good. Good. So then we would get into part two. I think we haven't really gotten into part two. Did Lauren make comments through all these different sections? Aaron, is that what she said? Because I didn't look at her comments.
Yeah, that's what she's saying. No, actually, I apologize. There aren't any comments from her.
Okay. Beyond what? Beyond 4E36?
Beyond, well, she didn't make anything on the hearing section.
Oh, on the hearing section. Okay.
Yeah,
So
yeah. Part two
place of-
forward, so 30 basically.
So the place of hearings and the notice of hearings and the postponement of hearings and the general provisions regarding purpose, order, limiting number of witnesses and written testimony. That's all okay.
Oh, she has one thing, but there's a highlight in 4034, but there's not really anything. It sounded like she just didn't completely finish her review. So basically nothing substantive. So
Okay.
that's all. So yeah, so really, I mean, we're at a natural stopping point if you all want to stop, but that's your prerogative.
Yeah, I think that makes sense because I think we want to get through some of the hearing stuff like 4E30 to let's see, 33 and then 34. Facts and where am I? Oh my, I passed 4E34. I have too many papers in my hand. Okay. Anyway, I don't
We've
know.
dealt with a lot of the more complicated sections. A lot of this, I mean, there's in-camera inspection, which is a bear, but that will be a bear to get through. But there's, if you keep in mind that there is a much higher level of diligence that is needed to maintain confidential information and the integrity of it. That's why we have to have it. And it's hopefully we don't are ever put in a situation where we have to do in-camera inspection. But if we do, it's good to have our framework there because it's just going to cover our behinds. And I know, like I said, it's going to be a bear to go through and it will be confusing. I've already whittled it down. So just FYI moving forward when we get to it. So it's our last real like complicated section, or I would say series of section. It's going to be a bear. We're just going to have to grit and get through it. So and maybe there'll be some more ways of condensing it. We can discuss it, and I'll continue to look at it as well.
All right. Well, I would ask the work group to take a look at the hearings part 2 and see if you have any comments, and we'll clear that next time and start to get into 4E35 and 36 and 37 as part of our old business. Barring any other old business, is there any new business or new action items that anybody wants to bring up? All right. Not hearing any. Thank you. So then our next date. So our next meeting, the whole board is meeting on September 12th. And we were talking about doing the third Wednesday of every month. So that would be the 17th of September. I can't move it to the 24th because I'm going to be away on the 24th. So maybe the 17th is the right Wednesday.
I'm gonna humbly ask that we kick it out after. If you're not available, Tom, could we possibly do it the week after?
Yeah, maybe because it's the week after the board meeting. Yeah. Yeah, I'm going to be away from like the 23rd until the 3rd. I'm going to Europe, and I'm going to be there from September 23rd to October 3rd. Unfortunately, so I'm gone for 2 weeks.
Would you be opposed to doing it after you get back?
No. I'm not. I mean, if we want to do it on the 8th, then we have a board meeting on the 10th. But at least, we have some more to report.
Yeah, and I'll send it out 2 weeks in advance anyways. And this one I'll send out before you leave. You're leaving on the 24th of September? You
I'm
said?
leaving on the 23rd, but I'm leaving at night. It's a European trip. So I fly out of Kennedy
Yeah,
at 7
All
o'clock.
right.
Yeah.
I'll have it sent out before you leave. That way you'll have it, and if you want to like read it beforehand, read it on the way back. That way you don't have to stress too much about it, and we don't have to rush as well. Because I know we have we have the board meeting, we have other work group meetings as well, and we have the privatization coming up as well. So that's why I just wanted to have a little bit of separation. That's all.
Okay. All right. Then let's say
Does that work
Wednesday.
for everyone?
Let's take a vote. Everybody good
Yeah.
with Wednesday, October 8th?
Yep.
And do you want to do?
Actually, this is Jim. I'm out of the country from October 1 till October 18th. So, but I'm don't hang up on me, or don't get hung up on my schedule. I don't think I'm an official member of this committee. I've been digging through while we've been talking. I've been digging through my notes, and I think I raised this question several months ago to Alicia, but somehow I got invited to this meeting, but I didn't have any. I finally found what we were talking about deep in my emails here, so I may be inappropriately attending this meeting. So,
we like having you.
And all
Jim,
this stuff,
sorry.
I have no. Greg, this is up to you. I have no list of who committee members are. I can't find it anywhere, and I've been
Can
scrolling
share that
through
with
stuff,
you now.
Okay, yeah, because Alicia and I had a back and forth way back in January that I didn't think I was on this committee, and that was agreed, and I got invited here again. So, but I don't think I'm on. I don't think I'm on the general mailing list of this committee because I had none of the attachments. So.
Sure. All right.
But it's a very interesting discussion. It just points out why people hate government.
Okay. Aaron, you had something to say?
Yeah, I'm glad I even thought about this. I don't know why it just popped in my head when you were talking, Jim. So remember the data regulations, right? That we were first just touched upon at the very beginning of all this. It's totally up to you, Tom, but in all the other big agencies, they're all included in the rules of practice. So if you like, for this next edit, I can do I can include them, and then that way we can get it all done in one shot. Obviously, I would do all the edits to the table of contents, et cetera, et cetera. It's your call. We can do whatever you like. We can treat it separately and just add it on later. It's your call. It's your call.
Yeah, I think we should do it separately.
Okay,
at some other time.
You
Yeah.
got it.
Yeah.
I figured I'd bring it up at least.
All right. So what time on October 8th? We want to keep the 9 o'clock time, or is this 11:30 time more interesting to people? Anybody? Brenda, do you care?
I prefer 9.
Okay. All right. So we'll say Wednesday, October 9th at 9 a.m. October 8th. What am I saying? Get my 8s and 9s mixed up. So yeah, October 8th, 9 o'clock. And that'll be the next meeting. And with that, and no further comments, I will open for a motion to adjourn.
So move.
Beautiful. Bob.
And Tom, I'll have the copy ready by the 19th. It'll all be sent out.
Okay. Very good. Thank you. I'll second the motion. All in favor? Aye.
Aye.
Aye. Okay. Very good. Thanks, everybody. Thanks for your hard
Thank you.
work. Appreciate it. Take care. Have a great weekend.
You too. You too.
Have a
Thank
good
you, you
weekend.
too.
Bye-bye.